during the middle of a medical malpractice deposition where I'm questioning the doctor. His attorney yells out, "Gerry, you can't ask that question. That's an unfair question." What? What are you talking about? You want to know what this is all about? Come join me on a walk through the neighborhood as I share with you exactly what this is all about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so now I'm in the middle of a deposition where I'm questioning a doctor in a case where my client sued this doctor for malpractice. I have the ability to ask the doctor literally hundreds of questions about what he did and why. I get to ask him what the standard of care was. I get to ask him opinion questions as if he were a medical expert. Importantly, I get to ask him hypothetical questions because in these malpractice cases, his version of the events is often different than our version of the events. So the whole point is I want to get him to assume that our version of the events are true, and in that instance, if he failed to do X, Y, and Z, that he departed from the standard of care by not doing A, B, and C, or something along those lines. So now I'm in the middle of questioning the doctor. And now, instead of yelling out objection and giving me a legal basis for the objection, the attorney yells out, "Objection, Gerry! You can't ask that question. That's unfair." Well, first of all, that is not a proper legal objection to say that something is unfair. If he thought that the question was inappropriate, he could certainly say that's inappropriate and maybe it calls for hearsay or some other legal basis, but saying that a question is unfair simply tells me he doesn't like my question. And he's going to do everything possible to prevent his client from going ahead and answering my question that he believes to be unfair. So how do I get around that? You know, a lot of younger attorneys turn around and they start arguing, having arguments with the defense lawyer, with the opposing lawyer. "That's not right, counselor. That's not a proper legal objection." And now they start bickering for the next 5 minutes. They're arguing about nonsense, about something that's not going to get changed. The defense lawyer is not going to allow his client to answer that question for whatever reason. He thinks it's an inappropriate question or maybe an inappropriate topic, or that there's some other legal basis for why I can't ask that question. So instead of arguing with the defense attorney, you know what I'm going to do? I'm going to ask a slightly different question. I'm going to turn it around. I'm going to rephrase the question. And you know what? He turns around and says, "That's still an unfair question, counselor." Okay, so what do I do in that instance? I'm going to rephrase it again. I'll rephrase it 5 times, 10 times, 15 times. Now, doing that does a number of things. It creates a record to show the fact that this attorney is being obstructive and not allowing the doctor to go ahead and answer questions that I believe are appropriate. And I've gone ahead and made great efforts to try and change the phrasing of my question around multiple different ways in order to try and get an answer to this question. Obviously, I believe that this question needs to be answered. And obviously, I have a good faith belief to believe that this doctor needs to answer my particular question. There are some younger attorneys who say, "There's nothing wrong with my question. I want the doctor to answer my question. He has to answer my question." Well, if the defense attorney turns around and says, "That's nice, but I'm not allowing him to answer your question," guess what? Now you're stuck. And you're stuck, and you're not getting an answer to your question. So in my opinion, the better practice is to rephrase the question 2 times, 5 times, 10 times, 15 times, 20 times if I have to. Or, you know what I'll do? I'll move on to another topic. And then, maybe half an hour later, maybe an hour later, I'm going to circle back and ask the question slightly differently so that now I do get an answer. But for the defense attorney to turn around and say, "That's an unfair question," no, that's not a proper legal objection. And if you don't like that, okay, I'm going to rephrase my question. And there's nothing unfair about it. I'm asking the doctor, I'm entitled to ask the doctor questions about his opinions. I'm entitled to ask him about the standard of care. I'm entitled, and I can and I will ask him about hypothetical questions. "Doctor, you don't believe that my client made a complaint of a lump in her breast. Isn't that right?" "Yes." "And there's nothing in your record to confirm that you recorded that she made a complaint of a lump in her breast. Isn't that true?" "Yes." I want you to assume, though, that Mrs. Jones has testified in this case that she did in fact go ahead and complain to you on that very first visit of a lump in her breast. If that is true, that she did in fact make a complaint, you would agree that good medical practice requires that you do a detailed history of that lump. Isn't that true? Yes. And you would also agree that good medical practice requires that you do a detailed physical examination. Isn't that true? Yes. and failing to do both a history and a physical in light of the patient's complaint of a lump in her breast, those would be departures from the standard of care. Isn't that true? Objection! That's an unfair question. Well, actually, it's not. It's an appropriate question because it involves this doctor's specific care and treatment of my client, his patient. And it involves a different version of events, of facts that my client has testified to be true. And although the doctor disagrees with my client's version of the events, I am permitted by law to ask him questions about what he would have done or what he did do, assuming my client's version of the events are true. So, let's get back to the question. Doctor, would you agree that failing to do X, Y, and Z when the patient comes in complaining of this particular breast lump, that would be a departure from the standard of care, correct? Objection! Doctor, you can go ahead and answer the question. That's exactly what happened in this scenario. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I recognize you're likely watching this because you wanted to join me on this walk through the neighborhood. Now, I realize you're watching this because you have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.